Good afternoon, everybody. My name is Ian Woods, and I'm a director of the London Shipping Law Centre. It is my pleasure to welcome everyone to this LSLC webinar organised in association with 36 Stone on sanctions, frustration and force majeure. I'm sure the war in Ukraine has touched all of our lives, if not professionally, then at least personally, with the increased cost of living and fuel costs that we're seeing at the moment. But the sanctions regime has certainly cropped up a number of occasions in my professional capacity so far, and I think that's just going to continue as the sanctions increase. So this seminar will seek to explore some of those issues that we're starting to see and have seen arising from in relation to the Russian sanction regime. We're very grateful to have Sir Bernard Ricks as our chairman for this afternoon's webinar. Sir Bernard will be very well known to a lot of the attendees, I'm sure, will need little introduction, but by way of a short reminder, Sir Bernard was formerly a judge of the Court of Appeal, and following his retirement in 2013, Sir Bernard has accepted appointments as an arbitrator and mediator in a wide variety of settings, including oil and gas, shipping, insurance, sale of goods and share transactions. Sir Bernard is an international judge at the Singapore International Commercial Court and a member of the Cayman Islands Court of Appeal. He is a professor of international commercial law at the Centre of Commercial Law Studies at Queen Mary University of London. So I think it's clear that Sir Bernard is very well placed to add some valuable insight into this topic and to conduct the roundtable discussion that will follow. So in that case, I am now going to hand over to Sir Bernard to introduce the subjects for today's seminar and also introduce the very distinguished panel of speakers that we have with us this afternoon. Sir Bernard.
Thank you, Ian. Thank you very much. It's a great pleasure for me once again to be involved in a session promoted by that wonderful organization, LSLC, taking me back to my legal origins in shipping, such a romantic, the most romantic in the international part of law. We've got a great lineup of panelists on tonight's highly topical subject of sanctions, frustration, and force majeure. I'll introduce them now in the order in which they're going to speak. So Andrew Ng is a young barrister tenant at 36 Stone. He comes from Singapore, is fluent in Mandarin, and is a law graduate of both Cambridge and Oxford. I put them in that order because that's the order in which he went to them, where he added several distinguished prizes to his first-class degrees. He's also an expert in wine. I don't know how well that will go with his sporting prowess over the years. Our next speaker is Kate Badley. She is a legal director of Preston Turnbull, LLP, specializing in shipping with a current particular focus on sanctions issues. So her expertise is particularly in focus here. And third speaker will be Stephen Mackin, now a partner at Clyde & Co., but in his time, before becoming a solicitor, he was with Shell, where he was a one-time, if you'll forgive me mentioning it, Cadet of the Year, and a navigating and cargo supervising second officer. He continues as a lawyer with particular expertise in oil, gas, and LNG related issues. Before I call on Andrew to speak, let me take just a moment to ponder how sanctions may fit into the context of the general law and its legal principles. There are perhaps three main components of that context: frustration, force majeure, and illegality. frustration is a legal concept which, unusually for English law, which on the whole mostly promotes the autonomy of parties to agree their own contracts and allocate their own risks as they would wish, sometimes, although it has to be said rarely, intervenes to put an end, if a party so claims, to a contract on the grounds that something has intervened without fault of the parties to make their contract impossible, or with the famous words of Lord Radcliffe, fundamentally different from what they had agreed in its performance. It's a concept based on doing justice, and the consequences of a finding of frustration is to try to settle accounts between the parties in some just manner. The principle is not too difficult to state, but its application may be very difficult. It's not a discretionary judgment, but it is what I've called, in a case of mine, a multifactorial assessment, which has to take account of all the circumstances of the case. And that perhaps is why in the NEMA, a case which is burnt into my conscience, the House of Lords stressed that a decision on frustration is almost a decision on fact, which an upper court should not disturb unless it feels that the tribunal of trial is plainly wrong. Force majeure, on the other hand, a concept better known to the civil than to the common law, is, in English eyes, rather a matter of express contractual risk allocation. Its effect depends, of course, on the agreed terms, but it can be said that force majeure clauses often involve the giving of notices with all the pitfalls that can accompany such a requirement, and that such clauses usually begin with the frustration rather than the termination, begin with the suspension, rather than the termination of a contract, but again may proceed to termination if the agreed conditions of termination, which probably involve another notice, prevail. And then illegality, particularly perhaps relevant to the imposition of sanctions, may be a component of frustration or force majeure, but it's a problem area all of its own. Its legal effect may depend on principles of conflicts of law, since illegality under a law different from the contract's proper law may or may not have relevance, depending on whether it interferes with performance in the place agreed for performance. And whereas much jurisprudence on illegality derives from an earlier era, prior to the reforming case in the Supreme Court of Patel and Mirza, it's perhaps not easy to predict how the new and much more flexible doctrine of illegality will bed down with the problem of sanctions. For instance, in the fascinating case prior to Patel and Mirza of the dredging fleet caught up in Iraq at the time of the invasion of Kuwait and of the UN and national sanctions which came into effect as a consequence of that invasion, the case of Royal Boscalis and Mountain, the Court of Appeal was rather tough on the fleet, which could only extricate itself from Iraq on pain of being forced by the Iraqis to pay out retention monies, arguably in breach of national and international sanctions, which had been kept back under the contract. Anyway, with those few words of introduction, let me call on Andrew Ng, who is going to speak about sanction clauses, and in particular, look at the case of MUR, which has been tried in the commercial court and is on its way to the Court of Appeal. Over to you, Andrew.
Right. Thank you very much, Bernard, for that very flattering introduction. I'll be speaking today on the decision of MUR shipping. However, perhaps the first thing it might be best to address is to further elaborate on the distinction between frustration and force majeure clauses. So frustration is the common law doctrine that deals with a situation where a contractual obligation is incapable of being performed. There are generally three requirements for a contract to be frustrated. The first is that there is a radical change in the significance of the obligation. The second is that the contract does not really distribute the risk of the event occurring, and this can be via an express or an implied term. And the third is that the occurrence was not caused by either party. There is a whole body of case law on the various aspects of these requirements. For example, whether frustration of purpose or perhaps an excessive delay amounts to a radical change in the party's obligation. Unfortunately, and as Sir Bernard Raikes rightly pointed out earlier, the test for frustration is very easy to state, but very difficult to apply. And nowhere is this better illustrated than from the inconsistent decisions of the coronation cases in the early 20th century, as well as the Suez Canal cases in the mid-20th century. Moreover, if a court were to hold that the contract was frustrated, then the contract would be brought to an end, and the parties' obligations would then be governed by the Law of Contracts, Frustrated Contracts Act 1943, a legislation which is notoriously opaque and difficult to apply. And in response to this, parties have started including force majeure clauses in their contracts. A force majeure clause is nothing more than a contract. It's nothing more than a clause in a contract that in essence, A, defines what a force majeure event is, B, sets out a list of requirements that the affected party must fulfill before invoking the force majeure clause, and C, defines the party's rights and obligations in the event the force majeure clause is successfully invoked. It has also become increasingly common for force majeure clauses to include as a prerequisite that the affected parties take, I quote, reasonable endeavors in order to avoid or mitigate the force majeure event. And it is this question of what reasonable endeavors entails that was the subject of the decision in MUR shipping. The decision in MUR shipping concerned a contract of affreightment where dispute arose pursuant to the force majeure clause. The issue on appeal was this: would a party's obligation to use reasonable endeavors to overcome a force majeure event include accepting a non-contractual performance? Owners who had invoked the force majeure clause say no. A party's duty to use reasonable endeavors can never include being under duty to accept non-contractual performance. Charterers, on the other hand, said that it might. Whether a reasonable endeavors includes a duty to accept non-contractual performance is ultimately a question of fact that should be assessed in all its circumstances. Turning to the facts of the case, the owners concluded a contract of affreightment with the charterers, where owners contracted to ship bauxite from Guinea to Ukraine. There were two relevant terms in the contract. The first relevant term was that payment of freight had to be in US dollars. The second relevant term was that there was a force majeure clause allowing for either party to effectively terminate the contract in the event that a force majeure event occurs. However, one of the requirements for successfully invoking a force majeure clause was that the force majeure event, I quote, cannot be overcome by reasonable endeavors from the parties affected. In April 2018, the US government applied sanctions onto the charterer's parent company. This led to the owners invoking a force majeure clause by sending a force majeure notice a couple of days later. In the force majeure notice, owners argued that it would be a breach of sanctions for the owners to continue with the performance of the contract of affreightment, as the sanctions prevented charterers from making US dollar payments, which was a contractual requirement under the contract of affreightment. Charterers responded by firstly denying that they were persons affected by the sanctions, and secondly, arguing that even if they were, charterers could make payments in euros, which would then be converted by owners' bank into US dollars before being paid out to owners. Charterers also offered to pay any additional charges associated with currency conversions or bank transfers as a result of freight being paid in euros. Owners refused to accept payment in non-contractual euros and declined to nominate ships under the contract of affreightment. Charterers had to obtain alternative tonnage and subsequently brought a claim against the owners. At the arbitration, the arbitrators found that the owners had satisfied all the requirements to invoke the force majeure clause, save for the requirement that owners use reasonable endeavors to overcome the force majeure event. What the tribunal found was that the exercise of reasonable endeavors required owners to accept the proposal made by charterers that payment would be made in non-contractual euros. And as a result, the tribunal held that the owner's case on force majeure was not made out. Owners then appealed to the High Court on the question of whether reasonable endeavors extended to accepting performance in non-contractual euros instead of contractual US dollars. The owner's case was that a party's obligation to use reasonable endeavors will never require the affected party to agree to accept non-contractual performance. Owners relied on two main cases in support of the same proposition. The first case was the 19th century case known as Booman and Fenwick, and the second was the 1963 case known as the Vancouver Strikes case. In the interest of time, I will only briefly go through one of these cases, which will be the Vancouver Strikes case. In Vancouver Strikes, the relevant clause in the charter party expressly gives charterers the option of loading either barley, wheat, or flour. The original loading of wheat was delayed by an elevator strike, and the charterers contended that they did not have to pay demurrage. The central question was whether charterers were contractually required to ship alternative cargo of barley or flour in order to avoid the effects of the strike. If so, then charterers would be in breach of their loading obligation, and demurrage would consequently be payable. The Court of Appeal in that case held that charterers were not required to load these alternative cargoes. This was because the contractual options in the charter party was a true, or what is known as an unfettered option, in which the charterers had but were not obliged to exercise. Owners then relied on the Vancouver Strikes case to argue that if a party who had an express right of election was not obliged to exercise that right of election to avoid a force majeure event, then a fortiori, a party who did not have an express right of election, such as the owners in the present case, cannot be expected to accept alternative performance not stipulated for in the contract. Turning to the charterer's submissions, charterer's case was that the court should start from the wording of the clause. Reasonable endeavors meant exactly what it said, and there was no reason in principle why it should not extend to accepting non-contractual performance. Rather, whether reasonable endeavors would include a duty to accept non-contractual performance is a question of fact that should be assessed in all its circumstances and would be one for a tribunal to make. Therefore, because the tribunal had, in the present case, accepted that owners' duty to use reasonable endeavors extended to them accepting non-contractual euros, owners' case on force majeure was not made out. Charterers then went on to distinguish, or attempt to distinguish, the cases relied on by owners. Ultimately, Mr. Justice Jacobs held that reasonable endeavors did not include accepting a non-contractual performance for two main reasons. First, Mr. Justice Jacobs accepted that the cases relied on by owners, in other words, Booman and the Vancouver Strikes case, did indeed support the proposition that reasonable endeavors could never include accepting a contractual performance. Second, Mr. Justice Jacobs was of the view that if the loss of a contractual right turns purely on what is reasonable in a case, then a contractual right becomes tenuous, and the contract is then necessarily beset with uncertainty, which should generally be avoided in commercial contracts. Now, turning very quickly to my views on the decision. This decision is a classic example of a conflict between two different approaches. The first approach is perhaps the more commercial approach favored by the tribunal, where the obligation of reasonable endeavors means exactly what it says, and whether it involves accepting a non-contractual performance. Now, that is a question of fact to be assessed by the tribunal. The other approach is perhaps the more legalistic approach favored by Mr. Justice Jacobs, where the parties' obligations are set out in stone in the contract, and that the party's decision to use reasonable endeavors can never include accepting a non-contractual performance. Ultimately, and speaking in a personal capacity rather than as an advocate, I think it is completely artificial to say that reasonable endeavors can never, as the owners contend, include accepting a non-contractual performance. Because this allows for blatant opportunism, where a party can insist on adhering to the contractual terms, where the proposed non-contractual performance is, in effect, equivalent to the contractual performance, such as in the present case. It is simply artificial to argue that because the contractual terms require payment to be in US dollars, owners could not be expected to accept payments in euros, which would have been converted by the bank to US dollars before it was paid out to owners. And as to the point raised by Mr. Justice Jacobs that such an approach would increase uncertainty as to the parties, well, that presupposes that parties can even agree on matters prior to litigation. Having such a bright line rule will not by in itself make parties' obligations crystal clear or reduce the need for litigation. Rather, what parties would do, or what I would certainly do, is to circumvent it by saying that, look, while I accept it as such a bright line rule that a party can never be obliged to accept non-contractual performance, on the true interpretation of the contract, there was no such contractual requirement to accept freight solely in US dollars. And we essentially end up in the same position with one party litigating against the other. I think that's all I have to say for now, and I'll perhaps pass my time back to Sir Bernard. Thank you.
Thank you very much indeed, Andrew. So now Kate is going to be the first of two speakers who are going to speak about sanctions. Kate, over to you.
Thank you, Sir Bernard. I'm going to give a very brief overview of the UK sanctions against Russia as they currently are. The UK sanctions apply within the UK. They also apply to UK persons wherever they may be. So if you are a UK registered company with an overseas branch, or if you are, say, UK crew on a ship working abroad, you have to comply with UK sanctions. In this particular area, sanctions were first introduced in 2014, and that was as a response to Russia's illegal annexation of Crimea. Obviously, back in 2014, the UK was part of the EU, and so it was the EU regulations that applied. And they were quite different to what we have today. They were primarily Crimea focused, so a lot narrower in scope. In anticipation of Brexit, the UK drafted specific legislation which would move over once Brexit took place. So the UK and EU legislation drafted quite differently, but at the time, 2019, it was very much still aligned with the European position. So the UK sanctions on Russia can be found in the Russian Sanctions EU Exit Regulations of 2019, and they came fully into force on Brexit, 31st of December 2019. There were some minor amendments to that legislation, but obviously since February and the commencement of war in the Ukraine, there have been some significant amendments. There have been, I think, 9 sets of amendments in total to date. And the stated aim of UK sanctions is to encourage Russia to cease actions destabilizing Ukraine or undermining or threatening the territorial integrity, sovereignty, or independence of Ukraine. So basically a deterrent. The regulations contain a broad range of sanctions. These include designation, so asset freeze and travel bans. They also include trade, financial, and transport sanctions. So briefly, asset freeze designation, if you are subject, if an individual or an entity is subject to an asset freeze, you cannot deal with their funds or economic resources or any funds or economic resources owned, held, or controlled by them. You also can't make funds or economic resources available to them. Funds, pretty straightforward, money. Economic resources is a kind of sweep up of everything else with which you can make money. So that would include transport and include vessels. Obviously, the Office of Financial Sanctions Implementation keep a consolidated list of financial sanctions targets, and there have been some pretty high-profile entries onto that over the last few months. A lot of oligarchs, some shipping entities such as Subconfloc. But it's worth bearing in mind that an entity might be caught by an asset freeze, even if it's not expressly named, but by virtue of being majority owned or controlled by a designated entity. The UK has extensive trade sanctions against Russia. Predominantly, they have export bans. So there are broad categories of goods. One such category is restricted goods, and that has military goods, dual-use goods, critical industry goods. Further, there's an export ban on energy-related goods and also luxury goods. And you need to look at the schedules to the regulations to work out whether the goods in questions that you might be seeking to ship are prohibited. They'll be either described or set up by commodity codes. There's also an import ban from Russia to the UK of iron and steel products. The justification for that is to limit Russia's exporting capability in a major market, but it's notable that there are other major markets that there are currently no import bans in respect of, including oil. There's also service bans. For an example would be technical services to ships. So, for example, a UK person would likely be in breach of UK sanctions if they took a role as chief engineer on a Russian oligarch's super yacht. Financial sanctions are quite extensive, but in my experience, they have pretty limited application within the shipping industry, because they're predominantly aimed at limiting investments, loans, etc. Of more relevance is the transport sanctions. There are sanctions in respect of aircrafts, but you'll all probably be more familiar with the port ban on vessels. There's currently no access to UK ports for specific ships which have a connection with Russia. The last point I'll make by way of brief introduction to UK sanctions is that a breach of sanctions can have very serious consequences. As a legal entity, you might be subject to a significant fine. As an individual, you may even be subject to imprisonment. So on that happy note, I will pass back to Sir Bernard. Thank you.
Thank you very much indeed, Kate. And now it's over to you, Stephen.
Thank you very much, Sir Bernard.
Well, just before you begin, can I say to our audience that if you have any questions for us, don't hesitate to put them up at as early a time as you would like in the Zoom function for questions, and we will get to them in due course. Thank you very much indeed. Sorry to interrupt you before you began, Stephen.
No, it's fine. Thank you. Thank you. So I was going to cover US sanctions and EU sanctions and broadly echo everything that Kate has said. The US, to a large extent from a shipping perspective, has been relatively easy in that they just embargo commodities. So they focus on sectors and impose sanctions against those particular sectors. So, for example, there is an embargo on the importation of Russian oil, a full stop. You can't bring oil from Russia to the US. Now that, the same as the Iranian sanctions, creates issues for parties involved in determining what is and what isn't Russian oil, particularly when oil has been imported lawfully from Russia into, for example, the EU, and is then re-exported, having been purchased lawfully by an oil company, and they have good title to it and then export it. It's embargoed in the US as still being Russian oil, but potentially not elsewhere. The EU, on the other hand, has introduced sanctions which are far more complex, take considerable care and attention to detail in determining whether you comply with them or not. The EU's approach has been to introduced sanctions in relation to Crimea in 2014 under EU Regulation 833. They have been subsequently amended by Sanction EU 2022 number 428, which introduced a list of designated entities, so companies and individuals that you cannot trade with, which would include the likes of Gazprom, Rosneft, Transneft, and Sovcomflot. But interestingly, Lukoil are not designated, so EU citizens and nationals are entitled and perfectly well to trade with Lukoil. An EU national or entity is not allowed to enter into a transaction or an indirect transaction in relation to the movement of oil from Russia shipped by any of those designated entities, unless the oil is moving into the EU, in which case it's permitted currently, but is going to be phased out in about 6 months' time under new EU registrations. The problem that creates is that the Russian oil industry is relatively opaque. So from a practical point of view, you need to look very carefully at who you're transacting with and whether any of these designated entities are involved in the process. So a ship owner on a voyage charter where the ship owner pays port charges, going to the port of Primorsk to load cargo. The port of Primorsk is owned by the majority shareholder being Transneft. So you breach sanctions by facilitating that, unless the vessel is deviated going straight back to the EU with Russian oil on board. In contrast, a time-chartered vessel doing the same ship would be permitted to go there because the ship owner is not entering into any transaction with the port charges being for the account of the time charterer, and provided the vessel is not owned or operated by an EU entity, it's free to trade there. So it's not caught by the regulations. There's a ban on insurance of Russian cargo, Russian oil, which is coming into place, which is causing issues. And similarly, things like STS operations, which are ship-to-ship transfers, which are getting increasingly common with Russian cargoes, moved out of the various Russian ports onto vessels and then shipped by ship-to-ship transfer. Issues arise in terms of insurance, enforcement of potential claims, even though there may be no issue in actually doing the STS operation. The risks are high in any STS operation, and the chances of enforcement of any claim which arises are accordingly very, very difficult. Just as by final way of aside, Gazprom undertake most of their trading through a German entity called Gazprom Neft Trading. Gazprom Neft Trading is no more as of today, or it still exists, but Gazprom's trading is now undertaken by a company called Commercial Energy Solutions GmbH, who are holding themselves out to be not Gazprom, albeit they're wholly owned by Gazprom. So from a ship owner's point of view or a charterer's point of view, I think the message has to be to take extreme care in dealings with anything which has potential sanctions implications, and to take care and be cautious in your dealings and check the parties that you're dealing with and consult your P&I club lawyers, defence association, to check carefully as to whether it's permissible or not, because as Kate highlighted, the implications of breaching sanctions are criminal. Thank you.
Thank you very much indeed. All right, I'm just checking my screen. No questions from our audience at the moment. So let's now go with our three panelists into a discussion mode. Thank you all three for your very enlightening talks. And let me kick off with the first question, although I would be perfectly happy for any of my panelists to ask a question of their own, and I'd invite them to do so. But to kick things off, let me ask this of my panelists. As a practical matter, how are contracting parties, owners and charterers, supposed to get to grips with the general rule of sanctioning authorities that corporate vehicles owned 50% plus by sanctioned parties are within the sanction rules? I mean, there is a lot of jurisprudence in the English courts arising out of, let's say, some naughty things done by bankers in Eastern Europe, which show how difficult it is to establish who owns what, who is the ultimate beneficial owner of a whole series of parent, child, sub-child, sub-sub-child, sub-sub-sub-child companies. So how is this going to work? Who would like to go first on that?
Shall I go first? I think the answer is with considerable difficulty. We regularly do sanctions queries and checks for clients and have access to various databases which we would use for our own internal compliance checks on new clients and utilize those in common with the majority of other people. So they give you a feel for what the ownership structure of various entities are. You then need to overlay that against the sanctions which are in place and have assurances as to the actual voyage that's going to be performed, because clearly most charter parties, despite a ship will load a cargo, will issue a bill of lading for a designated destination, but most charter parties allow the charterer considerable flexibility to change their minds mid-voyage and send the ship to a different destination. So the ship owner needs to take considerable care, and it's even down to things like port ownership. So where a designated entity owns or operates the port, or is a majority shareholder in the operation of a port, is the ship owner going to end up paying port charges as part of his voyage charter, or is that wrapped up in the freight, or is the charterer willing to make those payments to absolve the ship owner of responsibility for any underlying indirect transaction? And I think it's a question of taking care to think through the actual transaction which is being proposed to them, what the implications of performing that transaction are, and what options there are to vary that transaction, and how the ship owner best protects themselves against that in the contracting process.
Thank you very much indeed. Kate, Andrew, is there anything you want to add to that?
Yeah, I think there's another issue, which is Stephen was picking up the points about fixtures that are being proposed, but there's obviously business that's already been concluded and is underway when the sanctions landscape changes, and that's really challenging, especially if you have enough information for there to be red flags. If this was new business, you wouldn't touch it with a barge pole, but actually you need to prove that a company is a sanctioned entity before you can, say, rely on sanctions clauses to terminate an agreement. And it might just be really difficult if the burden's on you to get that information, because at the earlier stage you would say, well, I'm not going to enter the fixture unless I have sufficient KYC to have satisfied myself. But obviously once it's underway and sanctions have changed, it can be really challenging.
Thank you very much. Andrew, anything further?
Nothing from me at this point.
All right. Well, we've got a couple of questions from our audience, but because those questions will change the subject that I'm probing at the moment, I'm just going to ask a couple of questions further of my own, following up my first question, and then I will come to the questions in our Q&A function. So following up my first question, suppose an inadvertent breach of sanctions not noticed by either owner or charterer because, for instance, of the 50% corporate vehicle rule. There could be other reasons for an inadvertent breach of sanctions. Now, what would happen down the line between owners and charterers? I mean, it may be this wouldn't be picked up at a time to interfere with the voyage. It might interfere with the voyage, but anyway, there's an inadvertent breach. It might be said that both parties are responsible for it. How are the owners and the charterers going to work this out? Either usefully to avoid trouble or pathologically when they get involved in some dispute.
I can take that if you like.
Go on, Kate.
Yeah. Well, it seems to me that if there's been an inadvertent breach, and that the fixture has been concluded, the issues the parties are going to have is when the sanctioning authority comes knocking on their door. So the question is really one of sort of due diligence obligations. And really the parties, the aim with due diligence is to show a regulator, if this should happen, if they come knocking because of an inadvertent breach, that you did everything you could reasonably to have assessed the sanctions risk at the time, so that you have a defence to it. I don't know if Stephen's got any views on as between the parties, but I see that as more of a question to deal with the authorities once there's been a breach.
And yeah, I agree with that. And I think the issue as between the parties will depend very much on the contractual terms. So voyage charter party, the ship's probably contracted and taken the risk of carrying that cargo, whereas under a time charter party, the ship owner may have more of an argument that he was complying with charterer's orders and therefore should be indemnified for the consequences of complying with their orders. But it will depend very much on the contractual terms which have been agreed. The key is avoiding the issue as far as possible.
Yes. So following that up a little further, some sanction clauses may well have a due diligence element in them. But if one looks, for instance, at the BIMCO clauses, which I've done, one clause for time charters, another clause for voyage charters, they are put in terms of warranties, as far as I can see, rather than in terms of due diligence, if I've got that right. They're rather in favour of owners, so I'm just wondering. This is rather an important distinction between whether it's a due diligence obligation or a warranted no sanctioned party, no sanctioned port, no sanctioned activity situation.
I can take this. I think the due diligence obligation is in relation to compliance with the sanctions provision, the regulations. So the proving you have exercised due diligence is what will assist you in addressing the matter with the regulators who try to enforce or come to enforce the claim. As between owners and charterers, the BIMCO sanctions clause works on the basis of reciprocal warranties of no sanctioned entities, so the ship owner isn't subject to any sanctions or being designated the charterer warrants that they aren't. The key part of the BIMCO sanctions clause, though, is the provisions which relate to what happens if the voyage becomes sanctioned. And that is in owner's favour to an extent, and probably more so than other sanctions clauses which you see in charter parties from various oil companies and other trading entities, because it allows the voyage to be stopped, the cargo to be discharged so far as it's possible to discharge it, and for the ship owner to be paid for the ongoing costs of performing a voyage to somewhere else to get rid of this sanctioned cargo. Other clauses, so other sanctions clauses, have periods of time where the ship owner and the charterer can decide what to do, but don't provide for who pays for that period of time. And they, ultimately you'll be looking at, is there a breach, or are both parties equally innocent of breach, in which case the loss probably just falls where it lies. So, as always with any contract, it's the pre-planning and asking your questions of what if, and ensuring the contract reflects what the parties' wishes are for that clearly, in order to avoid the dispute arising in the first place.
Thank you very much. Anything to add to Stephen's answer? No. Well, let me go to Graham Dunning's question. He's at the top of the list, and Graham's question is this: would reasonable endeavours include applying for a licence to deal with a designated entity, even if it was dubious or unlikely that a licence would be granted? That sounds like one for you, Andrew.
Yes, I think that's right. I think the answer, perhaps, we should just look at it first based on current law and what the law should be. So based on the current law as it stands in the High Court, well, if there was a term in the contract, an express term or perhaps an implied terms, where the parties agreed that reasonable endeavours would not include applying for such a license, or that reasonable endeavours would not include, say, going beyond and above a means or taking actions that will almost certainly fail, then if there was such a term, then reasonable endeavours will obviously not include applying for such a license. But ultimately, this is a bit of a cop-out answer, because this will ultimately turn on the contractual interpretation of the contract. So we just have to look at the contract and ask ourselves, does the contract require us to take such action? If it does, then we have to do it. If it doesn't, then reasonable endeavours will not require us to do it. This is as the law currently stands. Now, the question of what the law should be, as I mentioned earlier, I am of the view that reasonable endeavours should ultimately be a question of fact and should be assessed in all circumstances. It could very well be, in 99.9% of the cases, reasonable endeavours will essentially not amount to accepting non-contractual performance. But there must be a leeway for this 0.01% of cases. For example, the case of Majeure, where it is obviously the case where non-contractual performance is in effect the same as contractual performance, because the owners would have received euro payments, which would have been converted by the bank to US dollars before it was paid out to them. So, as the law should be, I would say that yes, reasonable endeavours will or might include applying for a license to deal with a designated entity. But the question of whether what it actually entails and whether the parties will actually have to do that, well, that will ultimately be a question of fact and would have to be assessed by the tribunal. I'm very sorry, this is a bit of a cop-out answer, but unfortunately, I can't give a direct answer in the abstract.
We're at the early stages of what might be a flood of jurisprudence. Now, this is your chance, Stephen and Kate, to come in on the reasonable endeavours question. Is there anything you want to add to Andrew's answer?
Well, just on that particular example, which was licensing to deal with designated persons, that will ultimately, fall under the regulations, and it'll be governed by that, I suspect. So there are, under the UK regulations, there are specific circumstances in which a specific license might be given if the Treasury think it's appropriate. So if it doesn't fall within one of those categories and is completely hopeless, then I can't see how it would then be reasonable endeavours.
Stephen, anything to add?
I again, like Kate, I think this is a very practical issue in terms of a cargo becomes subject to sanctions, for example, and then you have to apply to the regulators to get permission or a license to discharge it. Yes, that would fall within reasonable endeavours. I think it is not unreasonable to do that. The problem which you get in a practical sense is that having gone through this process with Iranian cargoes, the chances of getting an answer out of the relevant authorities in any sort of timescale which is recognisable to most ship owners or charterers is very, very slim indeed. So you get into a whole, sort of a mesh of red tape, and there is inevitably delay. But I would have thought that still constitutes taking reasonable endeavours, because to not do so would be not exercising reasonable endeavours.
So following up on that answer, I mean, and your general advice, my speaker's general advice, that everyone is going to have to exercise caution in these matters. I mean, is this going to gum up international shipping quite a bit? I mean, we've had sanctions against individual countries, South Africa, Indonesia, North Korea, which perhaps is not the most important trading nation in the world, although Iran is. Did I say Indonesia when I meant to say Iran? But the current sanctions really, in their complexity and scope, and really very wide-ranging. I mean, is shipping going to be gummed up? Are we going to find, putting the question another way, are we going to find a greater percentage of world shipping going to the dark side? What's going to happen?
Let me comment, because I do have some views on this. I think the problem is some countries don't impose sanctions in relation to Russian oil. Other countries do. The countries which are predominantly users of Russian oil are the EU on the whole, and because of proximity reasons. So it's easy to move Russian oil into the EU. Come December, the EU will pretty much stop using Russian oil, save for some very limited exceptions. What that will mean for ship owners is that the ship owners who cannot then lift Russian oil, so ships will move elsewhere to carry oil which is still needed in Europe, but on longer voyages from elsewhere who can supply, so the Middle East to Europe predominantly. Other vessels, and we've seen a move from Sovcomflot to reflag or sell their vessels to various Indian entities, will no doubt continue to lift Russian oil because they're not subject to sanctions, but it will move elsewhere. So oil from the Middle East, which would have gone to India, will probably come to Europe. Oil from Russia, which would have come to Europe, will go to India. And I think that's how shipping is going to evolve over the next 6 months.
And there will be price differentials, no doubt.
Yes. Price differentials on the voyage costs will increase as a result of it, because everyone's performing longer voyages. Yes. And we're no longer using pipeline oil or gas.
Any additions to Stephen's answer? Yes, Kate.
Yeah, I agree with Stephen that I think what we're seeing is a redrawing of shipping patterns worldwide. Also, in terms of what I've seen with clients, is early on there was a mass exit, shall we say, from the Russian market, a lot of inquiries were, I want to get out of this. I just don't want any dealings with Russia. But on the other hand, we're seeing another set of clients who want to continue trading with Russia lawfully. So there seems to be, a separation there of what people's views are with dealing with Russia. But I don't think we're going to see the end of people willing to trade with Russia. And it's an opportunity.
Yes. Well, thank you very much. Let me go to a second question from our audience. This is from Joanne Waters, who asks, would it be in the interests of parties to jointly self-report to the authorities in the event of an inadvertent breach that they later discovered? So that's an interesting question. Anyone like to answer that? It's a good question, because
it's a good question.
I think Stephen,
we're always keeping very quiet.
Well, it depends if the authorities catch you. And here is the suggestion that when you discover an inadvertent breach, you should self-report. I would say that in the area of, let's say, the responsibilities of charitable trustees and their responsibilities to the charity commission, there is a whole concept of self-reporting actually there, and charity lawyers will advise you that it's very much in your interest to self-report rather than to wait to be caught. Anyway, what do you have a view?
I can certainly see that. I can see the logic of that, certainly. And there are certain reporting obligations as well. So, for example, if you've realised you've made funds available to designated persons under UK law, then you must report that. So, I would err towards that's probably sensible, but it all turns on the individual facts.
Yes. Anything else on that?
I think there is also the P&I clubs are certainly collating data relating to every shipment which is used for self-reporting internally within the UK. So ship owners are being obliged by their insurers to provide this information as a matter of course as part of the UK. So whether that then gets transferred over to the EU or the US or the UN authorities, I'm not sure, but I suspect it will be.
Yes.
Andrew.
Yes, I just have one more thing to add. And I think that another consideration that parties should have in deciding whether self-reports is in dealing with the question of illegality. Because eventually, if this matter goes to dispute, it is conceivable that one of the parties might raise the question of illegality under English law. And following the decision of Patel and Mercer in 2016, the court or like a tribunal will have a very wide-ranging jurisdiction to determine whether the claim should fail as a matter for illegality. So the court can, in the past, the court had to apply a very strict approach that so long there was some illegality, the entire claim will fail. But what the court does now will be to assess the illegality in all its circumstances, whether striking out a claim with a proportionate response, so on and so forth. And the fact that parties self-reported this inadvertent breach will clearly be one of the factors that might proceed in your favor. So that is one of the arguments that you might want to relay to the clients, perhaps in self-reporting such breach.
Yes, that's a good point. Let's go to another question, because we've got a few. This is from Jean-François von Hollebecke, and perhaps Jean-François will forgive me if I've mispronounced any part of his name. And the question is this: in the absence of express terms to that effect, such as sanction, force majeure provision, or other, does a sanction applicable to a particular transaction after it was entered into allow, or indeed force, the non-sanctioned party to terminate that agreement for illegality, or should it be limited to a suspension of the performance pending possible remedial action as was seen recently with changes of ownership in Russian companies held by sanctioned persons. Either way, is the non-sanctioned party entitled to claim compensation for the losses it may suffer as a result? So I think the essential first question is, is it a matter of termination or is it a matter of suspension?
Without a sanctions clause which would govern the mechanism for unravelling such an issue, if a party to a contract or the commodity which is being moved under a contract becomes sanctioned, then the performance of the contract by the non-sanctioned party, if it involves payment to them, would be illegal, depending on the nature of the sanction and the nature of the contract. The other element to it is whether the contract's capable of alternative performance. So if it's a voyage, for example, carrying a commodity which became sanctioned, so the US imposes sanctions on Russian oil mid-voyage without a grace period to perform the voyage, is it possible to deliver that cargo elsewhere lawfully under the contract? And I think that has to be a starting point to look at what the contract provides and whether the fact of the sanction makes performance illegal, in which case you can't perform and the contract must be terminated, or whether it is capable of performance by the parties lawfully and within the terms of the contract, unlike the Majeure case, which Andrew outlined, where the performance wasn't possible, save under the argument around reasonable endeavours and switching currency provisions in the contract. So I think it's a question of looking whether the contract is capable of performance or whether it just becomes incapable of performance, in which case it would arguably be frustrated due to the sanctions if there isn't a sanctions provision in it, and the losses would probably lie where they fall.
In that context, I suppose the position of the time charter is perhaps more easy to deal with than the position of a voyage charter, where alternatives are perhaps rather limited. Yes. Would either of Kate or Andrew or both like to add to Stephen's answer? No. Well, let's go to a question from an anonymous attendee. Thank you very much for your question, Anon. With reference to Andrew's section, what is the definition of a reasonable endeavour?
Well, I think that this is quite a short answer to this, and that the question of what the definition of what a reasonable endeavour is ultimately a term of art. It's like saying, we have to, in tort, we have to exercise a reasonable duty of care. It is very easy to state, but ultimately would depend on every single, every factual circumstance in play at the point of time. So it is difficult to give a definition in the abstract, but we say that this is ultimately what a question of reasonable endeavours will be determined by a court. And that's the best answer we can say at the moment.
Yes, I think I would hazard the answer that the whole point of a concept or phrase like reasonable endeavour is to avoid a definition. And the problem of definitions is that although they may seem to make things simpler by telling you exactly what you're looking for, they nearly always create terrible problems because it simply is not possible in the complexities of life to give a definition which is going to work fairly or well. And we find that in all kinds of circumstances, including, funnily enough, the language of lockdown regulations, which repeatedly talk about reasonable excuse without a definition, and just leave it to the courts to decide what a reasonable excuse is. I don't know of any cases which have gone to the court on reasonable excuse in lockdown situation, but that is typical of legislation. Anyway, I've chanced my arm on that, and I've interrupted Stephen or Kate making some additional comment to the last question, if you would like. No.
I think Andrew answered it perfectly.
Okay. All right. Well, let's go on to the next question, which is from Zixlin. I'm not sure if Zixlin is a name or some other kind of identity, but thank you very much for your question, Zixlin. And the question is this: could parties lose the right to depend on a force majeure clause because of sanctions that were announced earlier, but only became effective later on the basis that those sanctions were reasonably foreseeable? That's interesting. Andrew, you're taking that question in.
Yes, I was going to say that, of course, the answer is that it will depend on the clause in question. But from the question that you phrased is that if the sanctions were announced earlier and only became reasonably effective later, then it seems natural that such sanctions were reasonably foreseeable, and if parties had entered into the contract at a time, what do you call it, the lead up to the sanctions becoming effective, then that will be quite a serious instance of professional negligence to not, include or preempt such sanctions. So I would say that, short of actually seeing an actual contract, I would say, yeah, the parties would lose the right to depend on force majeure clause in such a circumstance, because at that time it was clearly foreseeable that the sanctions would come into effect.
Yes, and that would be consistent with a certain amount of jurisprudence, probably mostly of an obiter nature, in the context of frustration, where reasonable foreseeability of the risk which is alleged to be causing frustration may militate against a finding of frustration. But not always, of course, because you may even have an express exemption, but because the delay caused by the express exemption goes on until the crack of doom, as Lord Denning might have put it in one of his judgments, the contract is ultimately frustrated, although the existence of the exemption, perhaps in an off-hire clause or something like that, shows that the parties, that it was not only reasonably foreseeable, but actually foreseen. Stephen, Kate, would you like to add to Andrew's answer on that question?
I think what I was going to say in response to Andrew is that most shipbuilding contracts have a force majeure clause within them for the shipyard to provide a force majeure notice in the event of delays through things like strike. Now, strike and industrial action in Korea is entirely foreseeable and perfectly regular, and you get regular force majeure notices from your shipyard. So using that as an analogy, knowing that sanctions were going to be imposed in the future shouldn't prevent a force majeure clause being triggered, because yes, they're foreseeable, but you look to the terms of the force majeure clause itself to see whether it applies or not.
Okay. So two slightly different views on that. And here is another question from an anonymous attendee. Question: in terms of frustration, we experience many queries by owners and or time charterers where delays have become substantial. For instance, time charterers paying hire for weeks and weeks whilst waiting for demurrage. Perhaps time charterers not paying hire for weeks and weeks is what the questioner means, whilst waiting for demurrage from voyage charterers. So, my question is very simple. How long is a piece of string? How long is too long for the purposes of frustration? This is particularly relevant to recent issues in Ukraine. Yes. The great problem of frustration. Andrew, you have...
Yes, I was just going to say that this is, as what Bernard said, how long is a piece of string? I do understand that, I mean, because I do dispute, so perhaps I approach it a different way, but I do understand that most parties value certainty. They would like, if in the ideal world, they would like a checklist of 10 things. If I were to do, I will not be sued for anything. But ultimately, in reality, that is simply not the case. I'm sure perhaps Bernard might say something about this, but the courts generally like to have a residual discretion to determine everything based on all the facts of the case. And this is just something we just cannot answer in the abstract, because how long is too long? How long is it too long for the purposes of frustration? Well, the jurisprudence says it will depend on all the circumstances of the case. So that's just an unfortunate answer.
Yes. Stephen, Kate?
I think this harks back to the Sea Angel case, which you mentioned right at the very beginning. Provided hire is being paid under the charter party, then the ship owner is obliged to remain at the port, the vessel is on hire, and the contract is being performed, even if the charterer is waiting for payment of demurrage. Now, clearly, if hire stops being paid, the ship owner can terminate the charter party on the basis of failure to pay hire, but he's still left with the problem of a ship full of cargo which he needs to discharge, so he has no interest in terminating the time charter.
And the problem of the Court of Appeal, which says that failure to pay hire on time is not a repudiatory breach.
It's true. So I think it is the eternally difficult question, and the view I've always taken as a lawyer is that frustration must mean the contract is impossible to perform. So ships which are trapped or damaged or whatever, the same as the Suez Canal blockage caused, those contracts become frustrated because they're impossible to perform. But if the ship is just waiting and the delay is excessive, that's just unfortunate. This actually happened at the start of lockdown due to trade issues between Australia and China and restrictions in trade imports, where a significant number of bulk carriers arrived off Chinese ports carrying coal and were delayed for inordinate periods of time, sort of 6 months at a time, due to the imposition of strict application of rules which had never been enforced by the Chinese previously in terms of quotas for import of Australian coal in retaliation for some various Australian measures against Chinese nationals. The view was the charterers subsisted. The difficulty for the ship owner was that their ships were fixed at about a quarter of the then market rate because of the number of ships which were sat idle off China waiting to discharge.
Yes, it's not always that the running of demurrage or hire is to the advantage of owners. You never know. Kate, is there anything you want to add on that?
Only that in my experience, you seldom seem to get home on frustration for all the reasons that have been set out. And so I think this harks back to the earlier comments about, making sure you've protected yourself in your contracts with appropriate force majeure and sanctions clauses so that you can deal with these situations, which in hindsight is not helpful if you've got particular situations in mind. But it's very hard to make good a frustration of?
Yes, well, I think my general answer would be that this is one of the great difficult questions of the law. There are circumstances, because merchants like certainty, where the contract will stipulate it how long you've got. So a typical sale contract will give you the day for delivery. A typical shipbuilding contract will give you the day of delivery, and then we'll say you've got 150 days of liquidated damages before you get to the end of the rope. But there are lots of situations in which it can be very difficult for the law to say when you've come to the end of the piece of string. I mean, a constructive total loss of a trapped ship. We've seen that sort of problem, and the problem in the Sea Angel of the ship arrested by the local port authorities for pollution, and so on and so forth. And it's very difficult. And that's why decisions on this sort of question, decisions on frustration, are regarded by the courts as being almost decisions of fact rather than of decisions of principle. You just have to take all the circumstances into account, all the terms and expectations of parties into account, and come up with an answer which probably is going to satisfy no one. Well, it's going to satisfy one side and it isn't going to satisfy the other side. And all you can say is that that's the decision in that case, because that's the decision that the tribunal had to come to in that case. And unless it's plainly unsatisfactory and wrong, it will stand appeal. All right. Well, it's 6:15, and we've answered all the questions of our audience. There is just one question I want to ask the panel before we conclude. And it's perhaps an unfair question, and the panel may reply to me in terms that it's unfair, because I haven't given them any notice of it. But it's a conflict of law questions. So although sanction clauses, such as the BIMCO clauses, may well say that the sanction of any sanctioning authority anywhere in the world will work its effect for the purposes of the sanctioning clause, the general rule is that you have a proper law of the contract, and any other law, other than the law of the state of the proper law of the contract, is irrelevant, save in the situation where that is the law of the place of performance, the agreed place of performance. And so the question is, what if you have something sanctioned by US law, for the sake of example, but not under the proper law, and you don't have a sanction clause which tells you that the laws of all the world are relevant for the purposes of a sanction difficulty? Anyone want to? And you're perfectly entitled to say no notice and you don't want to answer the question, but if anyone has a view, let her or him speak it.
Well, if it was a US sanctions position and you as a party to the contract was subject to US sanctions, my advice would be comply with them. Because probably the repercussions of not doing so are going to be worse than whatever the potential fallout under your contract is going to be.
Right. Okay. Well, thank you very much. I think we've had a full discussion with the help of our audience and their questions, for which I'm very grateful. I'm very grateful to my panelists. I think I would sum up for my part only by saying that here is a new a host of new issues which may befall us, some of which may arise out of clauses. Some clauses might be rather tough and favour owners. Some clauses perhaps inserted by major shippers, like the big oil majors, may be more helpful to charterers than to owners. But it's obviously going to cause a lot of practical difficulties. They will have to be overcome with the usual good sense of owners and charterers. And where they can't resolve the issues, the lawyers, having given good sound advice at the time of the dispute, may have to sharpen their pathological tools in order to resolve disputes in the courts in the usual way, in due course. And as neither an owner nor a charterer, but as someone interested in the resolving disputes, I can only look forward to those possibilities. Anyway, I think that's how I would like to sum up, other than by repeating my thanks to my panel and to all those involved in putting on this webinar. And I will hand over to Ian to conclude matters.
Thank you very much. Just a very short thank you on behalf of the LSLC and 36 Stone to the panelists for investing the time. I know from personal experience, these talks take an incredibly long time to prepare, and we are very grateful for you giving up your time this evening to do that. It then just falls to me to thank Sir Bernard on behalf of the LSLC and 36 Stone for agreeing to take on the role of chairman this evening. We are very grateful, Sir Bernard, for you taking the time to prepare and attend this evening and sharing your insight through your very thought-provoking questions to fuel the discussion on the issues in this seminar. And I'm just glad that I wasn't a panelist for that last question, a very difficult one. But also, finally, thank you very much to the audience for joining us this evening. I hope you've enjoyed it as much as I have. And we look forward to seeing you at our next event, a hybrid event. So there will be the opportunity to attend in person, which is really quite exciting these days. The event will be on offshore energy contracts and disputes in the maritime environment on the 29th of June. And that is an event that is organised in cooperation with the IVRC. So we look forward to seeing everybody then. To Bernard, thank you once again, and also to our panelists, thank you, and good evening to everyone.